All right, it's 10 o'clock. We can go ahead and get started here. Good morning, Commissioner Cardenas. How are you doing?
I'm well, Mr. Chair. How are you?
I'm hanging in there, best as we can. All right, Ms. Linker, can you please call the roll for our Law and Policy Committee meeting?
Commissioner Cardenas,
Here.
Chair Matich.
Here. Thank you. Go ahead and move to item number 1. This is public comment for items not on the agenda. So do we have any public comment either by the telephone or digitally for items not on our agenda today? All right, hearing and seeing none, we'll proceed to item number 2. That's approval of our November 13th, 2020 committee meeting minutes. Commissioner Cardenas, did you have any edits or comments on the meeting minutes?
No, Mr. Chair, I do not. I'm prepared to move.
Excellent. I'll second that. Ms. Linker?
Commissioner Cardenas,
Yes.
Chair Matich.
Yes.
The motion passes.
Excellent. Moving to item number 3, this is our commissioner compensation policy. This is something we had talked about last month and something we had talked about at our commission meeting as well. And my understanding is that we have our general counsel, Dave Bainbridge, here today to talk about a couple options for implementing a new commissioner compensation policy. So, Mr. Bainbridge. Do we have Mr. Bainbridge?
Mr. Bainbridge is in the Zoom meeting.
All right. We can't hear him. There you are. We see you, Mr. Bainbridge.
I'm sure he'll be fine. Or not.
Yeah.
I could be wrong.
All right. I tell you what, why don't we, Mr. Bainbridge is experiencing technical difficulties, it appears. So why don't we go ahead and move on then to take item number 4 first, and then we can come back to Mr. Bainbridge. So for item number 4, this is interested person feedback on our pre-noticed amendments to regulations.
Oh, sorry, Chair. I've got you now.
Up. All right. Just in time, Mr. Bainbridge.
Not sure why these things are different every time I turn them on, but here I am now.
It's part of the fun. That's what it is.
Sorry about that.
It's okay. So what do you have for us for commissioner compensation policy options?
Okay, commissioner compensation issue is something Commissioner Cardenas had brought up, and what we're looking to accomplish is assigning the task to an uninterested parties to look at the current commissioner compensation policy and determine what, if any, changes should be made to that policy, and then go ahead and make those changes. The goal here, of course, is to keep the commissioners who are receiving the compensation out of the process of determining what that policy should be. Last time around, we had talked about a process, and I since then have kind of come up with another option I think the commission should consider in terms of how they would like to do this. So I'll lay out the 2 options and we can discuss them, and then we'll be ready to go forward with the commission meeting next week. This is an issue that's been agendized for the commission meeting next week. The first option is in line with what Commissioner Cardenas had suggested, involving the chair and the executive director in consultation with an ethics expert, an academic or the sort, and then a former commissioner, essentially coming up with a new policy if necessary or adopting the current policy of the commission. The other option would be a simple delegation of authority to one party to come up with a policy for compensation, potentially in consultation with the people listed before, former commissioners, government ethics experts, and I would suggest any member of the public who would like to provide comment about the issue could do so as well. The difference between these two options, option one, I would be a lot more involved in that it would require Bagley-Keene considerations and open meetings because you'd be creating a subcommittee. Obviously doable. We know how to do that. And it's somewhat easier and somewhat harder these days with Zoom, obviously, since I can't even get my volume to work some of the time. But that's one option. It'd be a little more structured, probably take a little more time, a little more staff time. The other option, just the simple delegation of authority to one party with the direction that they take in public comment from others and produce a policy at the end that is distributed to the commissioners. We could make, and I would recommend making any comments received during that process available to the public as well. So those are the two options as I see them. I think we could tweak some of them. We could tweak them in different ways if you wish, but those are kind of the two basic structures. So I wanted to give commissioners both those options before deciding how to go forward next week.
All right. Thank you, Mr. Bainbridge. Commissioner Cardenas, do you have thoughts or comments on the two options that Mr. Bainbridge just articulated?
I do, Mr. Chair. Thank you very much. Let me apologize in advance if the family dog interrupts these proceedings, which could happen at any moment. She's fascinated by the Christmas tree and not necessarily in a good way. I think Mr. Bainbridge, either option is preferable to the ethical challenge of having commissioners vote on their own income stream effectively. I have a question. By delegating the authority under option one, by delegating the authority to the chair, that automatically constitutes a committee, which then triggers Bagley-Keene?
If there is one other person involved. So if it was a delegation to the chair without the instruction of any other person necessarily being involved, or with the instruction that the chair create a body to explore the topic, that would not create a Bagley-Keene issue. It's just when you have more than one person involved after there's been a delegation of authority, that's when you create a subcommittee that would then be subject to Bagley-Keene.
I suppose then that raises the question of what it means to be involved, such that Bagley-Keene is appropriately invoked. If the delegation to the chair would be such that the chair would not necessarily establish a body per se, but that the chair would consult with perhaps a short list of enumerated types of individuals, ethics professionals, former commissioners, would that trigger Bagley-Keene? And with my line of questioning in this regard, I'm not suggesting that the Bagley-Keene type mechanism is to be avoided. I'm just trying to understand what would be the what is the real nature of the options before us.
Sure. And as often as the answer with Bagley-Keene, we don't know for sure because it hasn't been this issue hasn't been specifically explored. I think it depends on the wording and what sort of mandate or what sort of instructions are made to the chair. I think if it was encouraging the chair to solicit or receive information from parties, that would not trigger a Bagley-Keene issue. The public in general wouldn't. The more specific you get as to who you're telling him he needs to talk to in the process of coming up with this policy, I think the closer you get to having an issue of whether you've created a committee, even though you haven't named specific people. If you've named two types of people, My advice would be that's a little too limited, and you're running the risk of maybe it being considered having created a subcommittee in that instance. That's why my recommendation of encouraging, soliciting comments from former commissioners, government ethics experts, and members of the public. I mean, that then includes everybody except for the 4 people who are commissioners currently on the commission could comment on the matter. I think in that instance, you're safely outside of creating some sort of advisory committee under Bagley-Keene.
Mr. Chair, the last approach articulated by the General Counsel strikes me as being a very prudent way to go. I think not only is that better than the current system, but I think it's worthy of our support.
All right. So, Mr. Bainbridge, just so I'm clear then, what you just articulated was is that a variation on option 1 or is it option 2? I'm just trying to follow along with which option we're looking at here.
Yeah, that would be a variation of option 2. I think my option 2, I had suggested delegating to the executive director. So here it would just be a delegation of the authority to the chair with the power to revise the commission policy and after receiving public comment from parties such as former commissioners, ethics experts, and anybody else who wishes to comment.
All right. And so just so I think we all are on the same page here, if we took that approach, which I think that is a sensible approach, I agree with Commissioner Cardenas. If we took that approach and some future commission didn't believe that the chair had acted appropriately, nothing in this delegation would prohibit a future commission from changing the procedure or essentially looking at this again, right? So there is always an escape valve if there's some future point, some perceived misuse of this process. Is that right?
Yes, that's correct. 3 commissioners, a vote of 3 commissioners could change the policy.
Okay. All right. Commissioner Cardenas, I just want to put this out there. I mean, I think what Mr. Bainbridge has articulated is a delegation then to a single person who would then be consulting with a couple different categories of folks and and receiving comments from the public generally. That's the basic parameters as I understand it. Do you think there is as between making that delegation to the chair to do that as opposed to the executive director, what's your feeling on having the executive director do that instead of the chair?
My thinking, Mr. Chair, just as a per se matter, is that this type of delegation that deals with the authority, the powers, and in this particular case, the recompense, as strange as it may be for purported ethics body. I mean, when I accepted it, I was under the impression that there was no compensation, and under with that impression, I was honored to accept and serve. But having said that, given that as I believe is the case statutorily, there is at least some floor per meeting type of compensation. I don't think that that's the type of thing that should be delegated to the staff, even able chief of staff or head of staff, executive director. I think the Political Reform Act makes clear that the chair is a member of the body, but clearly first among equals, and there is a distinction there with a difference. The chair is really the only full-time person. The chair has a wider and deeper authority regarding the staff and their relationship with the executive director, and the chair is fully and duly compensated for the hard work. And so I think it's best left to the chair, which the Political Reform Act from day one recognizes as being, well, I don't know how else to say it, but the chair in a meaningful way, and I think to be able to set the compensation. Given that there's a floor provided by the act itself, with the understanding that a majority of the board could at any time take back the delegation and go in a different path. But let's understand that the reality of this, in such a situation where a chair has established a particular policy, and there are at least 3 out of the other 4 who disagree, then those 3 will have to publicly, this would need to be done, this is a policy change that would need to be done publicly. Those 3 would then need to argue publicly why they need to take the authority that the board gave to the chair to set their policy, to affect how many dollars flow into the personal wealth. They then need to articulate before the people of the state why they think that they have the authority and the justification to do that. And I think it should be so.
All right, fair enough. I appreciate that, Commissioner Cardenas. All right. At this time, let's call for public comment on this item. This is item number 3 that we're discussing. Do we have any public comment by telephone or digitally on this item? All right. Hearing and seeing no public comment on item 3. Commissioner Cardenas, it sounds like the proposal that you are making is that we delegate to the chair the authority to set the compensation policy for the other commissioners on our body in consultation with the articulated categories of experts, and then that be reported back to the full commission. Is that essentially the parameters of it, and pursuant to public comment?
Yes, and pursuant to public comment. Yes, that is precisely what I'm suggesting.
All right, Mr. Bainbridge, do you understand that proposal, and do you have any questions about that? Just so that we're clear with what you're asked to work up.
No, I understand that. I can draft it up and send it to Commissioner Cardenas if he's the one that intends to make the motion, and I can work with him on working on the language.
All right. Commissioner Cardenas, do you care to make the motion that we then recommend that for consideration at our next meeting to the full commission then?
Yes, Mr. Chair, that is my motion, and I fully intended and certainly hope to have the privilege of making the motion for the policy change that Mr. Bainbridge will draft at next week's meeting. This is important to me. Thank you.
All right, thank you. Well, if there's nothing else, then we'll go ahead and I think Mr. Bainbridge, you have your marching orders. We'll take this up at the commission meeting next week.
Okay.
All right, thank you.
Thank you, Dave.
All right, now we will move on then to item number 4. This is interested person feedback on our pre-noticed amendments to the regulation governing the Enforcement Division streamline and warning letter programs and new second tier streamline program. We have our Executive Director, Galena West, and our new Chief of Enforcement, Angela Brereton, to discuss that with us today. Just sort of big picture, this is something that is certainly very important to me. I think it's important to the commission. I see these changes as ways, really good ways, of freeing up some additional capacity of our enforcement division to continue focusing on the most critical and complex violations of the act, and also provide, perhaps a measure of relief to some of these first-time candidates and lower-level offenses who really, they're just trying to do the right thing and unfortunately got tripped up by some of the rules. So Ms. West, Ms. Brereton, welcome. Which one of you wants to take the lead on this?
I'll start us off. Good morning, Galena West, Executive Director. I just wanted to highlight, instead of going over, that's a great overview by the chair, instead of going over the long, arduous road up until now, where we presented this, I think 3 times at Law and Policy and also presented at the commission meeting, I'll just highlight the changes since the last Law and Policy meeting. So At the last law and policy meeting, and I also highlighted the changes in the regulations themselves so that you could see what changes were made since the last law and policy to make it kind of easier. But when you see it at the commission meeting, those will all just be underlined changes if we come to consensus on those. So there's probably 4 main points that we changed in response to the comments at the last LMP. So we strengthened the discretion language to make sure that the goal that the chair just cited to everyone is met. Because one thing that we have found is that this is great. These bright line rules are really good, but sometimes the examples that we've been giving are when somebody even does their amendments before contact from the enforcement division, and they have something that causes an exclusion from the streamline or warning letter programs, and then they have to go to mainline for someone who is obviously well-intentioned and trying to comply with the act. So we wanted to make sure that that was very clear, that we weren't pulling any punches, and it was very obvious in the regulation itself that there were going to be limited numbers of circumstances where the discretion will lie with the chief of enforcement. We also added the diversion program language into 18360.1. And that language, I'll just read for you to make it easy. The commission will develop a diversion program as soon as feasible to allow of education of respondents who have little or no experience with the Political Reform Act and commit minor violations in lieu of monetary penalties. So it puts it in a much more forward term, saying this is something that we want to do as soon as feasible, and this is some program that we're going to be working on in 2021 and spending resources on. So everybody's aware and it's on the table, and it'll be something that we can report back to the commission.
Excellent.
The third modifications were, we heard some comments from California Clean Money Campaign about the advertising sections. And I put in some changes to address that, to try to clarify about top contributors. So for tier 1, we're trying to emphasize that we're only talking about when the name isn't exactly correct, as opposed to it's actually missing. And in tier 2, we put in language to clarify that you can't have 2 top contributors missing and still qualify for Streamline. So we put in those. I haven't heard from Mr. Lang. Angela and I sent him an email reaching out, but we hadn't received any comments. So I was doing just the best I could based on what I had. So hopefully we can get some written comments and be able to address those more fully. And then the fourth change was I'd say the bulk of the discussion we had at the last law and policy was about the behested payments reports. And so that's really where a lot of the changes were put in. We added a time period, so that if you look, I'm going to cite it to you. So it's 18360.1. And if you look at page 15 is where it starts. So we'll start from there. The highlighted versions. We made sure that it specifies that excluding from both tier 1 and tier 2 is the perceived and actual personal benefit. We put in a definition of perceived personal benefit, which it leaves the discretion for the reasonable person standard to be applied by the enforcement chief. And the reason for that was to make sure that the enforcement chief has the leeway, because this is excluding or including from the Streamline program, as opposed to arguing in court what the reasonable person standard would be. So we wanted the discretion to be the enforcement chief is applying this reasonable belief standard. So we took the language from the probable cause standard, which is evidence sufficiently supports a reasonable belief or strong suspicion. So that way it's kind of proven language that we already use, and that the official received a benefit which includes evidence of a direct benefit to the family member of the official. So that's the perceived personal benefit language that we tried to give some sort of definition to it, and get some teeth to it.
Okay.
And then the last change in that is, if you go down on page 16, you'll see that mostly in response to the discussion that Commissioner Cardenas and I had, was that we added some more specificity to the maker of the payment. And I see a typo on line 14. It says the make of the payment. No matter how many times you look at it. So the maker of the payment is the named party or the subject of a governmental decision before the behester or the behester's agency. And this is the temporal component we talked about. While the decision is pending and within 3 months before and for 3 months following the date a final decision is rendered. So then that puts in a very similar timeline that we have to the contributions causing a conflict for appointed officials in section 84308. So again, it's language that's already in the act that we're adopting into this to try to keep some consistency, because I know in the act it gets confusing when there's different dates and all of that. So trying to keep some consistency. And then maker includes the individual decision maker, the entity, and any agent acting as the intermediary, easy for me to say. And so agent, it addresses the agency comment that we discussed last time. And then for governmental decisions regarding legislation, governmental decision only includes non-general legislation as defined, and it gives the section number in the act that is defined. So I think we made some substantial and good improvements to that section, added some specificity, and gave people a little more guidance as to what we're trying to say here, and gave the enforcement chief a lot more guidance as to what's to be included and excluded. So that's my summary of the changes.
All right. Thank you. Thank you, Ms. West. And just to kind of contextualize all of this, previously, meaning, well, I guess as including today, behested payments are not included within Streamline. This change in particular would allow behested payments to qualify for Streamline treatment. Which at the end of the day, it's a question of how are we allocating our enforcement resources. From the commission standpoint, this is really allocating people and time. And what we're saying here is most behested payment violations are probably simply not filing on time or missing some information, et cetera. Those types of violations will now be eligible for expedited treatment through Streamline and the lower penalties. But if we see evidence, or if the enforcement chief were to see evidence of either a personal benefit or something in the nature of the person who's receiving the behest also has business before the public official, we're simply going to devote more of our resources to investigating that and determining whether there's something else going on. Is that fair?
That's exactly right. And I would add that we include the general exclusions we already have for intentional behavior. So I think with all of these pieces together, it really emphasizes that we're trying to get these late filing kind of violations out of the main workload of enforcement, and keep in the main workload the more serious violations, the personal benefits, and the things that the commission has said our priorities are.
Right. So let me ask you a question about how this would operate in practical terms. So suppose that the chief of enforcement makes a determination on the front end that a particular matter involving a behested payment report, there is some evidence of a direct personal benefit, but then through so it is treated at least initially not through the Streamline, but instead it's considered mainline. But through subsequent investigation, you determine that there is no personal benefit. The evidence doesn't hold up for whatever reason. Is that matter then eligible to come back in and be subject to the fines under the Streamline program? Or would that be just that would continue through mainline, but presumably the fine at the end of the day, if any, would be adjusted accordingly?
It's kind of a yes and no answer. It depends on the facts, because we're also talking about perceived personal benefit. So this kind of gives enforcement that window of saying, I couldn't prove it, but there's a perceived benefit. It's almost like what Trent Lang was talking about before, where he was talking about intentional behavior, but also you can't always prove everything. And so this is trying to get to that where enforcement doesn't have to completely prove up a case to say, this is hinky enough to not get Streamlined. Sorry, I'm going to use Scooby-Doo terms today, apparently. But so it really is just one of those those catch-all kind of things to give the enforcement chief that discretion. But obviously, if through an investigation, it comes out that, oh, that's completely wrong, or those people aren't even related or whatever, then they would still then qualify for streamline. So it's not as black and white, cut and dry, but it's definitely giving that wiggle room to the chief of enforcement.
Okay, that's helpful to understand. Commissioner Cardenas, did you have thoughts or comments on the changes that Ms. West just went over?
I didn't until a moment ago. For the record, that was hinky,
It was inky. Yeah.
and that's a defined term.
Yeah, it means when it smells bad.
Oh, that's what you call it.
Yeah. That's what I call it in public meetings.
All righty then. I'll somehow find it within myself to resist the temptation to pursue the avenue any further. I think this is really ingenious, particularly the way that the finessing and the nuancing with respect to behested payment and a way that this might play out in a real world situation. I think the localizing of the authority and the discretion to make that kind of a reasonable person type of assessment with the enforcement with the chief of enforcement makes complete sense. Who knows how this may actually play out? When the rubber hits the road, and Ms. Brereton, you're presented with an actual fact pattern, but it seems to me that this gives you the authority, the discretion, but also some clear lines within which to maneuver and allocate your resources as best you can, and make judgments that are consistent with what the commission has established as its priority, while also affording those first time and not so hinky offenders an opportunity to not necessarily do hard time. But Ms. Brereton, I wonder if you would comment. You helped design this. You would inherit it. This will be an important part of your toolkit out of the gate. How do you think about this?
I agree with you that I feel like this gives me a very solid groundwork for establishing, the bright lines to begin with, but then giving me some clear guidelines too about where my discretion lies and what kinds of things I'm looking for. So I think putting it into practice will definitely let us know how it's working, but I feel very comfortable with it moving forward from this stage to see how it will play out.
Wish you the best of luck.
Thank you.
That's all I have, Mr. Chair. Thank you very much.
All right, thank you, Commissioner Cardenas. And just, I'm going to ask, I assume this to be the case, but I want it on the record. Again, our overriding policy concern here is freeing up resources enforcement to focus on those most complicated cases and trying to create avenues to push the lower harm cases out more quickly. So in your judgment, Ms. West and Ms. Brereton, you believe these changes will advance those policy goals?
Yes, I do.
Okay. That's all I need to hear. Thank you. Well, at this time, let's go ahead and pause and open this up then to public comment, both on the phone and digitally. This is our discussion of streamline and warning letter program. It's item number 4 on today's agenda. Do we have any public comment on the phone? Hearing none and seeing no digital public comment, I would then just move that Commissioner Cardenas, that we recommend approval by the commission of the changes proposed under item number 4.
Second.
All right, Ms. Linker?
Commissioner Cardenas,
Yes.
Chair Matich.
Yes.
The motion passes.
Excellent. And thank you, Ms. West. Thank you, Ms. Brereton, for your hard work on this. This is This looks great to me, and looking forward to the discussion with our colleagues next week on this. So thank you both.
Great, thank you.
All right, moving on to item number 5. This is our legislative update with our legislative counsel, Ms. Nakano. Good morning.
Good morning. Not much to report today, but I wanted to mention that the Senate and Assembly have set their calendars for the year, and they are available on their respective websites. It looks like the deadlines are substantially similar to previous years. Other than that, staff is continuing to research and develop the proposal ideas that were approved by the Commission previously, and to reach out to interested parties and potential authors.
Excellent. Commissioner Cardenas, did you have any questions for Ms. Nakano?
Just one, Ms. Nakano, good morning. Have committee assignments changed at all since whenever?
I'll have to double check, but likely since there are new members.
Ah,
All right. I take it when Ms. Nakano, if you were to receive information on the change of the composition of the chairs, the members of the committees that are relevant to what we do, that you'll update us on that.
Will do. Thank you.
Excellent. Thank you. All right. Moving on to item number 6. This is then our discussion of any items for our January 2021 committee meeting. Commissioner Cardenas, did you have any particular items? I presume we will have completed our work on the commissioner compensation policy and the streamlined regs we just talked about. Are there other issues or areas of inquiry that you would want us to take up in January through this committee?
no, not that I can think of, Mr. Chair. Thank you.
All right, very good. Then I think the only thing at this time that I think we would want to run through this committee would be just have a legislative update in the event that Ms. Nakano needs additional guidance or perspective on what she's working on.
Right.
All right.
And
Very
Mr.
good, then.
Chair, just I'm sure you're already thinking about it. I assume that that our state attorney general's approval by the United States Senate wouldn't be done by January, but my term is up in January in any event. So it's not clear to me whether I will be serving beyond December, but just for committee and agendizing purposes, just so we all understand that's a possibility.
Right. No, I do. I appreciate that. Although my understanding is that your term actually runs through the end of January 2020. So you're not, sorry, unless I'm wrong about that. I think you're on the hook for at least one more meeting, Commissioner.
No, it's not noon today.
It's not. Good try. Good try. Yeah, we're gonna enjoy your company a little bit longer, Commissioner.
What am I going to do with all these party hats?
Yeah, that's up to you, my friend.
It is.
It's outside my jurisdiction.
It is up to me, isn't it? You know it's up to you, Mr. Chair.
Yes,
You're due.
I'm due.
I like the due.
Oh, thank you. Yeah, I was.
Yes, I trust that was exclusively your decision.
It was my decision.
Well, good. Live with that, sir.
Yeah, thank you. I appreciate it, my friend. Well, on that note, we're prepared to make a motion to adjourn for today.
We're just starting to have fun. What?
Yeah, well, hey, we're going to get together next week too, so don't worry.
Already?
Yeah, it's coming up. The 17th, whatever that is. Yeah.
All right. Yeah. Whatever you say, Mr. Chair. Thanks very much. Is it time to adjourn?
I think it is time to adjourn. Yes.
All right. Who's on first? Sasha, will you call the roll? Oh, no, I'm sorry. That's your job.
Well, we have a motion and a second to adjourn. Ms. Linker?
Commissioner Cardenas,
Oh, with all haste.
Chair Madich.
Yes.
Motion passes.
Thank you, everyone. Take care.